I extend my hearty welcome to all the professors and scholars. It's the right time to introduce our resource person to you all. Dr. Narendran is currently working as an assistant professor in Rajiv Gandhi School of Intellectual Property Law, Indian Institute of Technology, Kharagpur. He worked as a head for IPR section in National Biodiversity Authority. In NBA, he played an instrumental role in the implementation of the Biological Diversity Act 2002. He has both theoretical and administrative experience in the field of IPR and biodiversity governance. He pioneered the ABS monitoring process through patent system in NBA and also was the officer in charge for the development of IT-enabled ABS monitoring system with the support of GIS GmbH under the Indo-German ABS partnership project. Dr. Narendran coordinated the module on biodiversity governance for IFS probationer in Indira Gandhi National Forest Academy, Dehradun from the year 2018 to 2021. He was the officer in charge of coordinating the India Biodiversity Award for IBA 2018 and IBA 2021 cycles and the NBA UNDP Biodiversity Samrashan Internship Program in 2019 to 2020 and 2020 to 2021. He has delivered many lectures on intellectual property rights and biodiversity law in various forums, including London School of Economics and Political Science, UK, United Nations CBD event in Kandy, Sri Lanka, Hanoi, Vietnam, Bonn, Germany, etc. He has also represented the government in many bilateral and multilateral meetings as nominated by the Ministry of Environment, Forest and Climate Change, Government of India. We are fortunate to have you with us, sir. Once again, I welcome you all for the today's session. Dear participants, kindly turn on the camera for the photo session. Thank you, dear participants. May our minds be open to the delights that can be revealed through. Now, without further ado, I will turn the time over to our eminent resource person, Dr. Narendran, to share his knowledge with us. Sir, the session is yours.
Thank you very much, madam. So I hope I am audible to all of you. If there is any issue with regard to my voice or my presentation, please let me know.
Yes,
please
sir.
feel free to
Your voice is very clear, sir.
Okay, thank you. So before I begin, I shall thank the principal, vice principal, the head of the department, and the management of St. Mary's College, and especially Dr. Professor G. Flora for inviting me for this program. It is indeed an honor for me to be part of this program, and I shall also thank, before I begin my presentation, I shall also thank Professor M. Shaktivel for inviting me for this program. So I was going through the brochure of the program. So I understand that it is a faculty development program. So all the participants in this program will be faculties of various universities or colleges in Tamil Nadu. So it is I felt very grateful after seeing the brochure, because I felt that there are other very eminent resource persons who presented who had taken class in the previous days. So from the brochure, I saw that Professor M. Shaktivel and Professor Raja Venkateshan had already spoken about different kinds of intellectual property rights in the previous classes. And I also see eminent practitioners like Mr. Rajavarman and Dr. Deepa, who has also given you some practical exposure to different aspects of intellectual property rights. So this has in fact made my job very easy. So today I will be speaking about biodiversity, traditional knowledge, and the interface with intellectual property rights. So I'll be speaking about something which you are not that much familiar about, because you are familiar about biodiversity, you are familiar about the research on biological resources, but you may not be familiar about the law relating to, or the law which regulates the research on biological resources. So before I begin my presentation, I shall tell you that if in case you feel that you are not familiar with any word or any concept that I am saying, then please feel free to interrupt and ask a clarification. But if you have some general questions, you can either put it in the chat box or you can keep it towards the end. So after my presentation, we can have a discussion. So I have structured my presentation that I will start with by explaining some of the terms or some of the concepts that I will be frequently using during my presentation. And then I will go on to share some interesting stories, related to the research on biodiversity and its use. And then I will give you a glimpse of international law, which regulates the biodiversity and traditional knowledge. And then I'll come back to Indian law, and I will also tell you what are the legal regulations that are applicable to you. And I will also tell you how you can apply and get permission for doing research on biological resources. And then I will also explain some of the other intricacies under the law. And then I'll conclude my presentation, and then we can open up for questions. So that is how I have structured my presentation. So before I begin, I understand that you are all from science or related fields. So you may not be aware of many of the legal terms that I may be using during the presentation. So for that preliminary discussion purpose, I will explain some of the words that I'll be frequently using. One is convention. So convention, I hope you all might have heard the word convention. So convention refers to an international multilateral agreement between parties. So we usually call as parties or states. So states or parties means countries in this context. So convention, you might have heard about Convention on Biological Diversity or some other international convention, which India or you might have also read in news or seen in television channels also. And we use another word called treaty. So treaty and convention, sometimes we use it in the same context. So when I use these terms during the presentation, it has the same meaning. So the convention or the treaty means a multilateral international agreement. So constitution, I need not explain to you, it refers to Constitution of India. So I may also be using the word act. So act refers to a legislation passed either by the parliament or by the state legislature. So in previous presentations, you have already discussed the Patent Act or the Copyright Act. So these are central legislations enacted by the Parliament of India. So the Constitution gives some powers to the central legislature, that is the Parliament of India, and also to the state legislature, that is the State Assembly. So in Tamil Nadu also, we have a government as well as the Tamil Nadu State Legislative Assembly is there. So the State Legislative Assembly is empowered to enact legislation on certain subject matters. So for that purpose, the state also can bring in legislations. So those are also called as acts. So whether it is a central enactment or whether it's a state enactment, if it is passed by either the Parliament of India or by the State Legislative Assembly, these are called acts. So under the acts, some of the powers will be given to the government. So the government will be entrusted with some powers to enact some procedures or prescribe some procedures or prescribe some rules and regulations. So for that purpose, we usually call it as rules. So rules are not usually approved or passed by a legislative assembly or by the parliament. So under the act, the government can make the rules. So it need not be placed in the parliament or the state legislature usually. So, and similarly, I'll be using the terms regulations, guidelines, etc. So these are also delegated legislations. So when I use the word act, it is enacted by the parliament. So when we look in the context of biodiversity, there are different acts. So you might have heard about the Forest Act, the Wildlife Protection Act, the Environmental Protection Act. So these are different enactments. And we also have the Air Act, we have the Water Act. So these are different acts passed by the central legislature, that is the Parliament of India. And there are also state enactments, like Tamil Nadu also have a State Forest Act. So similarly, Kerala, Karnataka, and other states also will have a Forest Act. So similarly, the Police Act and State Police Act will be there. So there are different legislation. So with regard to protection of wildlife, protection of biodiversity, protection of ecosystem, there are different legislations. So what the fundamental difference between the Biological Diversity Act and the other enactments like the Environmental Protection Act or the Forest Act or the Wildlife Protection Act is that it focuses on a different thing, that is biodiversity or the biological resource. So Wildlife Protection Act focuses on wildlife ecosystem, or Forest Act deals with whatever is taken from the forest. It can be the timber, other forest producers, other minor things. And Environment Protection Act is also a comprehensive legislation which regulates certain kind of activities. So Biological Diversity Act was enacted by the Parliament in 2002. So there are different bodies which are established under the Biological Diversity Act that I will explain in my coming slides. So before I go ahead, you are already familiar because of the previous presentations. You are already familiar about the different categories of intellectual property rights. So in the second day, I think you have already learned about the Patent Act. So patent is a protection, a kind of intellectual property right for protecting inventions. So similarly, we have copyright, industrial designs, semiconductor chips, plant varieties protection, trademarks, geographical indications, trade secret, etc. So in my presentation, I will be mainly talking about the interface of biodiversity and traditional knowledge with mainly patent and plant variety protection. So the purpose of today's discussion, we will be focusing on only two different categories of intellectual property rights. One is patent and next one is plant variety protection. So patents, I need not explain to you. You are already familiar about what is patent. So patent is a protection granted to new inventions. So one thing I need to clarify here is, I hope you already learned this in one of the sessions. But when you apply for a patent, you have to file a comprehensive document. So you have developed a technology in your lab. So in your biotechnology department or in your botany department, you have found out something or you have developed a new technique in the form of a new invention. So when you apply for a patent, you have to explain in detail about the particulars of the invention. So you have to describe the invention. So it is just like when you publish a scientific article. So in the article, you will explain whatever you have done and what is the new thing that you have found out. So similar to that, when you apply for a patent, you will explain those things in detail. So this I'm explaining because it is relevant in the coming slides. So when we go to the coming slides, we need to understand that in patent mainly is intended to protect new inventions. So whoever wants to obtain a patent, they have to file a patent application. So patent application will be in the form of a detailed descriptive document in which you will explain in detail your invention and what are the different, you can also give graphs, diagrams, and structure of your invention. It can be also in the form of pictures that are just shown in the slide. So similar to that, you will describe in detail your invention and it will be filed for the purpose of getting a patent. So today I'll be speaking about the interface between biodiversity and intellectual property rights. So you know that biodiversity, the word biodiversity, I need not explain to you because you are more familiar than me, because you are teachers, you are faculties working in the field of biodiversity in biotechnology or botany or some other science related subject. So you are more familiar because I am from the law background. So better than me, you know what is biodiversity. So biodiversity as such encompasses everything that you can perceive as having a form of life around us. So it doesn't include soil or it doesn't include things which doesn't have life, but it includes everything that you can perceive as part of the life or part of your ecosystem. So there are different sectors which uses the different components of biodiversity. So for example, if you go to a supermarket and try to buy a soap or a shampoo, so now there is an increasing tendency that you will always look for a bio-based product. So if a particular product is advertised as having is based on neem or turmeric or some other biological resource, then we have a tendency to buy that particular product. So there is something fancy about biodiversity or bio-based products. So different industry sectors like pharma industry, biotechnology industry, cosmetic industry, food industry, fragrance industry, all those industries are now doing a lot of research on biodiversity. So when you work in your lab also, you know, because you also develop, like I have been told that in biotechnology lab or botany lab also, you also work on different biological resources. So you also develop new technologies. So you know the scope of research on biodiversity. So that when you buy a cosmetic product or when you buy a pharmaceutical product, instead of being advertised as a chemical product, if it is advertised as a bio-based product, it is having an attraction. So people like it. So that is the scope of research in biodiversity. Similarly, the village people, the local people or the tribals, they depend on biodiversity for food and livelihood. So these we can see we can see the uses of biodiversity from two different perspectives. So one is the industry. Second is the people who depend on biodiversity, like the tribals or the local people, for their food and livelihood. So we need to regulate the industry, but at that same time, it has to be opened up for the use of tribals, local communities, or farmers who conserve the bioresource. So these are two conflicting interests that we need to look at when we study about biodiversity or a regulation on the access and use of biodiversity. So you also know about, I hope you also might be familiar about the international politics regarding the use of biodiversity. Biodiversity is not evenly distributed across the world. It is unevenly distributed. So some countries like India has rich biodiversity, but industrial development is also not evenly happening, because in some countries they are industrially advanced than India. So we know that many of the products that comes from China or Europe or some other countries, so they are industrially advanced in some sectors compared to us. So they are the main users of biodiversity. So you look at most of the pharmaceutical companies, or you look at most of the cosmetic companies, they'll be either US or Europe based companies. We have some good companies in India as well, but I'm just saying that most of the companies, which when we look at this industry as a multi-billion-dollar industry, then most of these companies are based either in US or Europe. So the users of biodiversity, the industrial users of biodiversity, are mainly from US or Europe or from China. But we are the suppliers. Most of these bioresources goes from us only. So if you look at turmeric, neem, all these are our resources, Indian resources, which are being utilized by industry in some other country. So then the problem is, if it is used for just food consumption, you know that it is only having a very limited profit, because if you make a food product, or if you sell it as a food product, just as a commodity, you take turmeric from the field and then it is just sold as a commodity, the margin is very limited. But when it is converted into a pharmaceutical product or a cosmetic product, then it turns everything. It completely changes everything, because then it is a multi-billion-dollar industry. So then the poor farmer who conserve the resource. So the poor farmer has been conserving or cultivating this resource for a long time. So he will get only very meager amount from this. So whether there has to be some mechanism which provides that whenever this is being utilized by an industry, at least a certain percentage of it should flow back to the original conserver of the resource. So we will see this when we go ahead. So let us start with one story. So here I'm going to 2-3 stories. I don't know whether you will be able to relate with these stories. So this Pokali rice, I don't know whether you have heard about the term Pokali rice. Some of you might have heard, because you work in the field of biotechnology or botany, then you will be knowing. So Pokali is a rice variety. It is mainly cultivated in few districts in Kerala. So it is a highly saline tolerant variety. So it is cultivated in wetlands near to the sea. So in fields that are adjacent to the sea. So during the high tide, the seawater will come in. So it will be flooded by seawater. But this the peculiarity of this rice variety is that it will grow more than 1 meter height. So even during the high tide, only the tip of the rice will be above the water level. Still, it can survive. Even in salt water, it can survive. So that is the peculiarity of this variety. So we know that there are only very few plant varieties or several varieties that can survive in salt. So if you develop a variety that is having saline tolerance, I need not explain to you the economic importance of such an invention. So in your lab, if you work on a biological resource and you introgress a gene into it to make it a saline tolerant variety. So then if you travel from Chennai to Pondicherry or to Thoothukudi in the ECR, East Coast Road, you know that, that there are a lot of salt areas that are very near to the sea, which are not at all cultivated. So if you develop saline tolerant varieties and you are able to cultivate in those lands, you know the economic significance of such an invention. So this Pokali rice variety, if it was a physical class, I could have asked you how many of you have heard about this. But usually when I take class, I understand that only very few people might be knowing about this variety, because it is cultivated in only very limited areas in Kerala. So these are some patent applications. This is one patent application filed by some inventors from Washington University. Sorry. So this is another patent application filed by some inventors from a Chinese university. So what they have done is they have identified the gene that causes saline tolerance in the Pokali rice variety. So we don't know about this variety. We don't know about our own biological resources. But people in other countries, they come to India, they do research, and they identify these kinds of biological resources, and they take those resources to those countries, and then it will be utilized by their industry. So in these cases also, this has happened. These are two different patent applications. The first one is by Washington University in US. Second one is by a Chinese university. So what they have done is they have studied the Pokali rice variety, and they have identified the gene that causes saline tolerance. And this saline tolerant gene was introgressed into other cereal plants to make them saline tolerant cereal plant. So it can be, you can, in this method, you can develop a lot of transgenic cereal plants. So this is a highly sought after invention, which is having huge economic significance. But now you look back and see the condition of the poor farmer who has conserved this resource. So it is cultivated only in very less area, and many people don't know about the economic significance of this particular rice variety. So we usually take, when you go to the supermarket, we buy the cheapest rice variety, or we may have a particular liking towards a particular kind of variety. So then we go and buy that variety. So we don't usually go for these kinds of peculiar rice varieties. So this is not having a huge market. So the poor farmer during the season only he can cultivate. So he will be making very less profit. And it is not, he will not be making, he will just make whatever is enough to meet his ends. But then you develop an invention based on this variety that is having huge economic significance. Then should the farmer be getting something, at least a percentage of the benefit that the company or the university is going to make. So similarly, let us look at red Santis. I'm sure you might have heard about red Santis. So this is cultivated, or this is not cultivated, this is a forest also. So it is present only in a few areas in Andhra Pradesh border. So in the Tirupati hills. So this wood is very peculiar. So it has a lot of peculiarities. You are all familiar, I'm sure, about this variety. And then compared to India, this is having a huge market in countries like China, Japan, and Korea. So this is actually a restricted resource. So that means it is not publicly available. Many times it's not publicly available. And most of the trade happens through smuggling or illegal trade. So once it is confiscated, sometimes the forest department or the state government will, or the central government will auction it. But other than that, the trade is very limited. So it is not available compared to other timber varieties. But then you look at the number of patent applications filed on this variety, it is very surprising. So I am referring to 2-3 patent applications here. So this is filed by a university in China, and another one filed by a university in Korea. So what we see here is these varieties are going, maybe through smuggling, they are going to other countries. So this refers to 2007 and 2016 applications. So these varieties are being illegally taken to other countries. And they are also doing research on these varieties and developing inventions, which is having huge economic significance. So then whether our country also should get benefit when these are used in an economic, for an economic purpose, or for a commercial purpose when it is used. So let us go to another variety, which you may be familiar with compared to the other two examples. So this is Kilimuk mangoes. So Kilimuk mangoes, you know, it comes from 2-3 districts in Tamil Nadu. So I don't know whether it is the photo of Kilimuk mango. So I have taken it from internet only. So this is a European patent application, which is for Mangifera indica as a serotonin-1 activating agent. So this patent application, what they have done is they have sourced Kilimuk variety of mango from Tamil Nadu. So in the patent application itself, they were explaining that it is taken from Tamil Nadu region. So they are telling that it's organically cultivated mango variety taken from Tamil Nadu. And this patent application is actually filed by a Swiss company. So what they have done is they have taken Kilimuk variety of mango, and then they have converted it into a powder form. And they are going to market it as serotonin-1 activating agent. So you know that it is having a huge economic significance. Instead of taking the mangoes, the users can actually buy this powder, and then it can be put in milk or some other water or some other solvent, and it can be consumed. So athletes or similar kind of persons who are engaged in physical activities can use this for building energy. So then this is also having huge economic significance. So now think of a farmer, whether he will be able to export this variety into countries like Switzerland or Europe or US. So it will be very difficult for a farmer to do it by himself. Some cooperative societies or some traders may be doing it, but still the market is very limited. But you look at a company based in Europe, they are coming to Tamil Nadu. They may not have come to Tamil Nadu, but somehow they came to know that there is a variety like this, and they do research on these varieties. They develop inventions, and they are also making huge profit. So now you also might have heard about some of the biopiracy. I don't know whether you have heard about the word biopiracy. So biopiracy usually refers to illegally using Indian biological resources or biological resource from any country, and then doing research and taking patents without giving any benefit to the original person who has conserved this resource or who has cultivated this resource. So you take the example of the Pokali rice variety. A poor farmer is cultivating it. So without getting his permission, without giving any benefit to him, someone else in some other country does research on it and then take a patent, and that person is making benefit out of it. Similar is the case of the Kilimuk mango variety. The poor farmer is not getting anything, but some other company in Europe or US is doing research and they develop an invention, and then they trade this and make huge profit without giving any benefit to the poor farmer. So this is usually known as biopiracy without taking the proper approval process. So I'm not sure whether you have heard about the turmeric case, neem case, basmati case. All these happened in 1980s, 1990s, but this is continuing to happen even now. We can come across very different cases like what you have seen in the previous examples. But this is rampant. This is happening worldwide. So there are different sectors which uses biological resource. So what these sectors they do is either they will directly go to the field, they do the research, or else they search for publications. So when you do some research, you will also be publishing papers. So from these publications, they come to know that a particular variety, a particular biological resource is having a potential for doing research in a particular field. So maybe if I cite an example, it can be like it is having a therapeutic effect with related to some disease that is affecting your skin. So like turmeric, so a therapeutic use for treating a skin disease. So you find a resource, you do some research, you come across this therapeutic use, so you publish a paper. So what this industry will do is they will search for these kinds of publication. They will identify that this particular resource coming from this particular region in Tamil Nadu or Karnataka or Kerala or Telangana or Andhra Pradesh has this property. Then they try to access the resource and then do their research, and then they develop an invention. So this is happening in pharmaceutical sector, biotechnology sector, cosmetic sector. So almost all sectors, which is big industries, are all now focusing on biological diversity based research. So if you look at the patent statistics, you can see an increasing trend here. So this is from 2019, I'm referring, that you can see that in biotechnology sector, there is an increasing trend. So wherein the number of patent applications filed every year is increasing. In the patent applications from India in this field will be very limited, but mainly from China, Europe, and US, the number of patent applications filed every year is increasing. So that increasing trend shows that there is a huge demand for bio-based products, and there is a lot of research happening in biodiversity related sectors. So now I'm coming to some legal principles. So which some of this you may be familiar with. If there is something new and there is something which you are unable to understand, please feel free to prompt me at any time. I will explain in detail. So it's a well-established principle in international law that states have jurisdiction to decide rules on how natural resources or assets are used. So if it is a physical resource in our country has sovereign right to decide how it is being utilized. So if it is a physical resource like our land or some coal or petroleum resources or gas resources, natural energy resources. So all these, our country has sovereign right to decide the way in which these resources can be used. So we know that there are different legislations, different policies by central or the state government to decide on these matters. So when we come to biological resource, the very interesting part is it is having a physical part and it is also having an intangible part. So physical part refers to the thing that you can touch. So if you take turmeric in your lab and do research, so you are dealing with the physical part. So I'm taking an example of a person working in your lab, a student working in your lab, taking a resource like turmeric. So they do take turmeric, they do some research. So that person is, that student or that faculty is dealing with a physical resource. Then you publish a paper. In that paper, you are explaining the use of that particular resource or something that you have found out. So that becomes the intangible thing. That means that information can be used or accessed by any person from sitting anywhere. It is available in the internet. So once you publish in a good journal, it is available across the world. So it can be accessed from anywhere. So the intangible part can be in the form of genetic sequence information. It can be in the form of traditional knowledge. It can be in the form of scientific knowledge, like what you publish in a paper, or it can also be in the form of digital sequence information. So the intangible part refers to mainly the genetic information or information related to the use of the resource. So it can be something that you publish in an article. It can be a traditional knowledge. So traditional knowledge actually refers to knowledge which has been generated in previous generations, and then it is a traditional asset. So the knowledge as to the use of a resource. So if you take a very common example, the use of turmeric for cosmetic application is a traditional knowledge. Similarly, the fungicidal effect of neem is a traditional knowledge. So these are traditional knowledges. So traditional knowledge is also kind of intangible resource. So I hope you understand the difference between physical resource or the tangible resource and the intangible part, which is in the form of the digital sequence information or an article which you have published or traditional knowledge. So now the issue is, we know that there are different laws that regulate the physical part. So we have the Forest Act, we have the Wildlife Protection Act. And if it is just the physical part, you can also regulate the export of the resource. So you can use your the implementing machineries like the customs or the other police or other enforcement agencies to restrict the export of these resources. But then what about the intangible part? Intangible part is available across the internet. So any person can access from anywhere. And it is easy to transmit also. If it is a digital sequence information regarding a particular resource, it can be transmitted, it can be sent by many means, and it is very difficult to detect. But it is a physical part. We can have strong laws, or we can also use our enforcement agencies to detect the export. So there comes the relevance of a international legal regime for regulating access to biodiversity and regulating activities like research, commercial utilization, patenting, etc. So at international level, there is a convention called Convention on Biological Diversity. I hope you have heard about this convention. So it's an international convention, and we usually say that it is near universal because there are 197 parties, 197 countries who has signed the Convention on Biological Diversity. So compared to any other treaty, any other agreement at international level, the Convention on Biological Diversity has a greater acceptance because it has 197 parties. So almost all the countries around the world, except very few countries like United States, are party to the Convention on Biological Diversity. So our country, India, Government of India, is also a signatory to Convention on Biological Diversity. So under the Convention on Biological Diversity, we have a protocol called Nagoya Protocol, which came into force in 2010. So we need not go through in detail, but just for our understanding, we should know that there is a convention like Convention on Biological Diversity, and there is also a protocol called Nagoya Protocol. So as I said, there was a confusion as to who owns the resource. So if you take the example of turmeric or neem, which is Indian biological resource. So if some utilization is happening in some other country, whether our country has the right to stop it, or what is our country's right to deal with such a situation. So the Convention on Biological Diversity was the first agreement at international level to deal with these kind of situations. So CBD reaffirmed that states have sovereign right over their own biological resources. So if it is a resource from India, then our country has sovereign right over that particular biological resource. So it says that we have the sovereign right. That means we can enact our own legislations, our own acts. So that is how, that is why I explained the word act in the beginning itself. So it can be a central act or it can be a state act. So our country has the right to have acts. So it can be in the form of a central act like Biological Diversity Act, or it can also be in the form of a state enactment like the Forest Act. So there is also another principle that is coming in the Convention on Biological Diversity. So that you can see in the form of the circle. So whenever utilization of a biological resource is happening, it has to be in a sustainable manner. So the focus is on sustainable use of biological resource. So the use of biological resource is not prevented or prohibited. It is permitted, but with the condition that it should happen in a sustainable manner. So what is sustainable use? So if you take a particular biological resource, it should be the access or the way in which you do the collection should be in such a way that it doesn't affect it doesn't lead to an extinction of that resource. So it should be replenishable, so that when you take the resource, for example, you are planning to do research on a particular species, then instead of taking the root, you take the leaf. Then the resource is as such, you are only taking its leaf. But when you take the root or you uproot the plant, then the entire plant is gone. So, but sometimes you have to do research on root also, that is different issue. But then as far as possible, the utilization should be in a sustainable manner. So the use or access to a resource has to be restricted. It has to be regulated so that it will be ensured that the use or access happens only in a sustainable manner. And once the access happens or once the use happens, then there should be equitable sharing of benefits from its utilization. So when an industry uses the resource and they make huge profit, a particular part, a percentage of the benefit has to be shared back to the conserver of the resource. And then it contributes to conservation of biodiversity. So the entire focus is on conservation of biodiversity, which is ensured through a regulation of access and ensuring that sustainable utilization happens. And that whenever utilization happens, there should be equitable sharing of benefits also. So we will see this in detail when we go ahead. So when I use the word genetic resource or biological resource, it refers to any material which is having actual use, actual value, or potential value. So I have heard many people saying that this is a waste material. So you take a leaf which had fallen down from the tree. So we usually treat it as a waste material, or you take any other resource which we may usually, for example, the firewood, we usually call it as waste material. But when you look from the purview of Biological Diversity Act, or the Convention on Biological Diversity, we cannot call it as waste material. So once a use is identified, then it is having a potential value. And so it can never be a waste material. So we cannot say anything is waste material. If you are referring to biodiversity, nothing can be a waste material. If a use is identified, then it is having a potential value, and then it will be a genetic resource or the biological resource. So as I told, the Convention on Biological Diversity is at the international level, one of the first legal instruments to say that the countries have, or it reaffirmed that the countries have sovereign right over their own biological resource. But how to implement this principle? So for that, we have the Nagoya Protocol. So this is another international instrument. So just for our understanding, we should know that there is Convention on Biological Diversity and also the Nagoya Protocol. So, and this doesn't stop here. So I refer to two international agreements. One is the convention as well as the protocol. So similar to that, we can see that this principle is reflected in many other international agreements or in many other discussions. So there is also a discussion going on at World Intellectual Property Organization regarding intellectual property, genetic resource, and traditional knowledge. So there also the countries are looking at how they can integrate the biodiversity concerns or the concerns related to the use of traditional knowledge into the intellectual property legal framework. So this is happening at international level. So I don't know how many of you have heard about the Regional Comprehensive Economic Partnership, which has been recently concluded between China, Japan, and some other ASEAN countries, and Australia and New Zealand also. So India is not a signatory to this international agreement. But in this international agreement also, you can see that there is reference to biodiversity and its interface with the intellectual property rights. So from the previous examples, the stories that I have told you, I hope now you have understood that whenever a patent is taken on a particular biological resource or the use of a particular biological resource, the patentee will have the exclusive right to use that resource or to use that resource for that particular purpose. So unless that the conserver of the resource or the holder of the traditional knowledge is not deriving any benefit, so then it is not acceptable at all. So that is why he have a convention like Convention on Biological Diversity. So India is also a signatory to the convention. And so, on the basis of this convention, we have some national legislation also in India. So we have the convention on. So after signing the convention on biological diversity, we have enacted a national legislation in India. So in India, we have the Biological Diversity Act, which was enacted in 2002. So if you ask me what is the national law in India, or what is the law in India which regulates biodiversity for the purpose of research, commercial utilization, and intellectual property rights, it is Biological Diversity Act. But as I told in the beginning itself, there are different legislations which deal with different aspects of biodiversity, like the Environment Protection Act, like the Wildlife Act, like the Forest Act. There are different legislations. But the law that regulates research, the law that regulates commercial utilization, the law that regulates patenting is Biological Diversity Act, which is a central legislation enacted by the Parliament of India. So we know that we have a federal polity. So there is state government as well as the central government. So the constitution also gives some powers to the state government and some powers to the central government. It is almost equally distributed. So when it comes to forest, wildlife, and different aspects of environment, it comes in the concurrent list of the constitution. So both the central government and the state government has power to make laws. So under the Biological Diversity Act, some of the powers are given to the state government and some of the powers rest with the central government. So the powers given to the central government, there is Biological Diversity Rules 2004 enacted at the central level. And there is also state rules enacted by all the different state governments. So Tamil Nadu also, there will be one state rule. So similar to that, every state will have, in Kerala, there is a state rule. In West Bengal, there is another state rule. So every state will have a state rules related to the Biological Diversity Act. And there are also different notifications. We'll go in detail when we go to the coming slides. So the Biological Diversity Act provides for a 3-tier institutional mechanism for regulation of activities, different activities related to biodiversity. So now I shall ask you why you should learn about this. What is its importance? Why you should learn about the Biological Diversity Act? So I shall tell you that that preliminary understanding of law is very much important. Whether you are working in the botany or chemistry or any other sector, or even if you are not a faculty or you are working in some industry, or you are a farmer or any other person, you should have a minimum understanding of the law. So it is very, very important. We should at least know the law relating to the field of our activity. So if you are a farmer, you should know what are your rights, what are the laws that regulate farming. So you should have a minimum understanding. Similarly, when you work in a university, you should be knowing your university statute. You will be knowing about your service rules. So similar to that, you should also be aware about the law that regulate your research. So that is why we are studying about the Patent Act or the Copyright Act, because when you develop an invention, you have to go for patenting. So you should have a minimum idea of about what is patenting or how you can secure a patent. So similar to that, Biological Diversity Act is a law that regulate your research. It's a law that regulate the way in which you can take patent. So you should have a minimum idea of what is Biological Diversity Act, what are the activities regulated under the Biological Diversity Act. So otherwise, your research or whatever activities you do may lead you to some complications. So under the Biological Diversity Act, there are 3 main institutions. So one is the National Biodiversity Authority, which is under the central government. So National Biodiversity Authority is located in Chennai. It's very near to Thoothukudi. So under the central government, there is National Biodiversity Authority. And under each state government, there will be a state biodiversity board. So Tamil Nadu also has a Tamil Nadu State Biodiversity Board, which is also located in Chennai. So every state will have a state biodiversity board, and every local body will have a biodiversity management committee. So every local body means it can be a panchayat, it can be a municipality, it can be a corporation, it can be a block panchayat, it can also be a district panchayat. So every local body, even the local body near to your house, also will have a biodiversity management committee. So from my understanding, I think it is the block level. In Tamil Nadu, it is block level. So every block will have a biodiversity management committee. So in even the block in which your department is situated, your college is situated, or the place where you live will have a biodiversity management committee. So under the scheme of the Act, of the Biological Diversity Act, some of the powers are given to National Biodiversity Authority. Some powers are given to State Biodiversity Board. Some powers are given to Biodiversity Management Committee. So it depends upon what activity you do, what is the nature of your activity, or what is your legal status. So if you are a foreigner, some of your activities are regulated by National Biodiversity Authority. If you are purely an Indian citizen, you don't have any foreign engagement, then it may be regulated under the State Biodiversity Board. And the Biodiversity Management Committee is also given some powers under the Act that I will explain in detail. So as I told, National Biodiversity Authority is located in Chennai. So it was established under the Act, 2002 Act. It also has offices in some other locations. So first, before I go to the National Biodiversity Authority and the State Biodiversity Board, I will explain to you what are the roles of Biodiversity Management Committee. So Biodiversity Management Committee exists in every local body in the country. So in all the local bodies in our country, there will be a Biodiversity Management Committee. So it has an advisory role. So whenever the National Biodiversity Authority or the State Biodiversity Board grants some permission, they will consult with the Biodiversity Management Committee. So if you take the example of a block in Thoothukudi, and a particular biological resource is taken from the Biodiversity Management Committee in Thoothukudi, and National Biodiversity Authority is about to grant approval, then the NBA will consult with that Biodiversity Management Committee in Thoothukudi before making a decision. So this is a consultation process or a decision-making process in which there is a consultation, there is people's participation. So that is how the decision-making happens under the Biological Diversity Act. So whenever a decision is taken, both the National Biodiversity Authority or the State Biodiversity Board will have to consult with the Biodiversity Management Committee. The Biodiversity Management Committee also has a regulatory role. So whenever a biological resource is taken from the jurisdiction of a Biodiversity Management Committee, they are empowered to levy a fee. So they can levy a fee under the Act. And they also have a role in documentation of biodiversity and TK. So when we speak of traditional knowledge can be in oral form. So you also may have heard from your ancestors or your parents or grandparents that about the use of a particular biological resource or its therapeutic use or its medicinal use. So from Ayurveda or Siddha or some other sector of medicine. So these are all having lot of applications. So whatever biodiversity you see around us. So whenever we have an injury in your hand, or if you have headache, you use some bioresource. So you put some biological resource in the water and then boil it or drink that water. So there are different things that we do in our common life. So these are all traditional knowledge. But then if it is not properly documented, after some time it may be completely lost. So now we know the traditional knowledge from our parents or grandparents. So now they used to live closely with biodiversity. So they used to work in the farm. They used to interact closely with nature. But our generation, it is a little bit different. So we work in sophisticated offices. So it is slightly different, and we don't have that direct interaction with nature many times. So we don't know about many of these traditional knowledge. We only know about whatever our parents or grandparents have told us. So then after our generation, these things may be completely lost. So then it has to be properly documented. So whatever we know now has to be properly documented. So the Biodiversity Management Committee is given with this work of documenting traditional knowledge and the different biodiversity components that are existing in their jurisdiction. So now I come to what is regulated and what is not regulated under the Biological Diversity Act. So as I told, the biodiversity. So when I use the word hereafter, when I use the word biodiversity, I am referring to biological resource. So the word biological resource is clearly defined in the Biological Diversity Act. So biological resource covers almost everything that you can perceive as having a form of life. So it can be a plant, it can be an animal, it can be a fungus, it can be a DNA, it can be a microbe, it can also be anything that you can perceive. It can be a marine organism. So it can be anything which is having a life. So all these are covered under the term biological resource as defined in the Biological Diversity Act. So that is something peculiar about law that also you should be familiar with, that we may have a general understanding about a particular term. The word biological resource, if you hear the word biological resource, you may have a general understanding. But in law, actually, you have to see how it is defined in the act. So if it is given a proper definition, then you have to follow that definition. You cannot use you cannot use the meaning that it has in its common parlance. You have to use the definition that is given in the act. So the word biological resource is defined in the act. So it is defined to mean plants, animals, microorganisms, or all everything that you can see as having a form of life. So it includes its genetic material. So it includes DNA also, and it can also be parts or byproducts or derivatives also. So all these are part of the word biological resource. So whenever any component of biological resource, any component of biodiversity used for any of the purposes that I have mentioned here, then approval is required. So the different activities are, you can see in this slide, that research, transferring of research results to a section 32 person, commercial utilization, biosurvey, bioutilization, and obtaining of IPR. So these are the 5 different activities which are regulated under the Biological Diversity Act. So when I say research, so I have heard people saying that I didn't use turmeric, but instead I bought a packet of turmeric powder from the market. So now these are all commonly available. So I didn't take coconut from the field. Instead, I have purchased only coconut oil. So these are some common arguments we hear. But if you look at the definition of biological resource as given in the Biological Diversity Act, whether it is turmeric, whether it is turmeric powder, whether it is coconut, whether it is coconut oil, all these are considered as biological resource. So whether it is in the form of extract, whether it's in the form of powder, it is still considered as biological resource. So if you do research on these components of biodiversity, you may require approval. So here there is a slight difference, that if you are an Indian citizen, and not a non-resident Indian, then you doesn't require any approval for doing research. So if you are a faculty working in the St. Mary's College or any other college in Tamil Nadu, and if you are a purely Indian citizen, then you doesn't require any approval for doing research. But if you are a if you are a foreign citizen, or if you are a non-resident Indian, then you have to take approval even for doing research from the National Biodiversity Authority. So as I told, if you are an Indian citizen, or even if you are an Indian citizen, if you are a non-resident Indian, so for example, you are going abroad for doing a postdoc. So during the time of postdoc, you have become a non-resident Indian, and then you want to do research on an Indian biological resource. Oh, I shall clarify this also. This act deals with Indian biological resource. So Indian biological resource means any resource that is taken from India. So when you have become a postdoctoral fellow in a foreign university, you try to do research on an Indian biological resource, then you have to take approval from National Biodiversity Authority. So similarly, if a foreign faculty is coming to your department, or a foreign research scholar is coming to your department, and then he is working in your lab and doing some research on Indian biological resource, then he has to also take the approval from National Biodiversity Authority. Similarly, you enter into a collaboration with a foreign agency. So take for an example, you are getting a grant from a UN agency or similar other agency for doing some project. So then if you are doing research with a foreign funding, you have to take the approval. So these are some distinctions that you need to understand. But generally for Indians or Indian citizens, or Indian citizens who are not non-resident Indians, approval is not required for doing research. And then transferring research results to a section 32 person. So if you are an Indian, you are free to do research. So once you do the research, you want to transfer it to a foreign person. So for example, you have a foreign counterpart. So you want to consult with him. So then you send your research result to him. So for that, actually, you have to take the approval. But if it is a publication or participation in some seminars or some conferences, then approval is not required. But if it is for doing some research or doing some commercial utilization, that you are transferring this to a foreign person, then you have to take the approval. Similarly, you also need to understand that the foreign entity also includes a company situated in India, but having foreign shareholding or participation in management. So you take the example of any well-known company, like any company in cosmetic sector, like Hindustan Unilever or Palmolive or any other company, Himalaya or any other company. So all these companies will have might have listed their shares in the stock exchange. So they will also have some foreign direct investment. So even if it is 1% foreign shareholding, then they are all coming under the clause of foreign entity. So in that case, they also have to take the approval for doing research. So only Indian citizens, Indian companies, are exempted from taking approval for doing research. All other foreign citizens, foreign companies, or companies with foreign participation in shareholding or management have to take approval for the purpose of doing research. And when you come to commercial utilization, if it is a purely Indian citizen or an Indian company, they have to take approval from the State Biodiversity Board. So if you plan to initiate a startup, and the startup is planning to use some biological resource for making some products. So I have heard about startups which make some products like sanitizer or some soaps or something, which are all bio-based. So in such cases, if you are a purely Indian, you don't have any plan to take any foreign investment, then you have to take the approval from the State Biodiversity Board. But if there is some foreign funding or any foreigner is involved in this, then you have to take the approval from the National Biodiversity Authority. So commercial utilization is regulated alike, whether it's an Indian or a foreigner. But then if you are an Indian, you have to take approval only from the State Biodiversity Board. But if you are a foreigner, you have to take the approval from the National Biodiversity Authority. So similarly for biosurvey and bioutilization also, if you are an Indian, you don't require approval. If you're doing biosurvey and bioutilization for commercial purpose, you need to take the approval from the State Biodiversity Board. But if it is for some research purpose, then no approval is required. And similarly, if you are a foreigner or a foreign company, then you have to take the approval from the National Biodiversity Authority. And then I'll come to the most interesting part, that is obtaining of intellectual property rights. So when you speak of biodiversity and research on biodiversity, that is what I explained in the beginning itself. In this today's presentation, we will be discussing about mainly two categories of intellectual property rights. One is patent and next one is plant variety protection. So when we speak of patent mainly deals with inventions relating to any sector. So if you develop an invention and you are planning to take patents, and for developing that invention, you have used a biological resource or an information related to biological resource, you have to take the approval from National Biodiversity Authority, irrespective of whether you are a foreigner or a foreign company or an Indian company. So irrespective of your legal status. So even a faculty in working in a college or a university in Tamil Nadu, purely an Indian citizen, doing research, and then you want to apply for a patent, then you have to take approval from National Biodiversity Authority. And it doesn't matter whether you are a foreigner or a foreign citizen, still you have to take approval from the National Biodiversity Authority. So this approval process and other regulations I will explain in detail when we go ahead. So the approval process is actually, it can be applied online. So I'll also show you how to apply online. So once it is approved, if it is from National Biodiversity Authority, you have to apply in online. If it is from State Biodiversity Board, you have to apply in the prescribed form. So once you make the application, then the approval will be in the form of a written agreement. So once you apply, then it goes through a process, it goes through a defined process. And once the process is over and the authority decides to grant the approval, you will be asked to sign an agreement. So the agreement will stipulate a percentage of benefits that you shall share to the authority. So if you are simply taking a patent for academic purpose and you don't have any plans to commercialize it, then there won't be any benefit sharing at all. The percentage will be fixed in the agreement, but then you need not pay anything. You just have to pay the prescribed fees, that is 500 rupees. But if you are planning to do commercial utilization, then whatever benefits you derive, you may get some royalty, or once you commercialize it, you will get some profit. So a percentage of that has to be given to the State Biodiversity Board or the National Biodiversity Authority. So then that amount will be used for mainly three purposes which are given under the Act. So one is channeling benefits to the benefit claimers. So if a benefit claimer, like the farmer that I have told you in the case of Pokali rice or similar other cases. So if such a person is identifiable who has conserved this particular resource, then that amount will be given to him. If that person is not identifiable, it can be used for conservation and promotion of biological resource or socio-economic development of the area from where such resource is taken. So these are the different purposes for which that amount will be used. So then it again contributes to the conservation of biodiversity. So this is a mechanism by which it generates finance for conservation of biodiversity. So here you can see that the circle that I have explained in one of the slides about the conventional biological diversity, that it ensures that whenever utilization happens, it is regulated. It is regulated because you have to take approval from National Biodiversity Authority or the State Biodiversity Board. So it is regulated to ensure that the utilization happens in a sustainable manner. So then once the utilization happens, a condition is set wherein when you generate profit, when you make money, a percentage of it has to be given back. So there is equitable sharing of benefits. Then how these benefits will be used? So that benefits will be used to either to provide it to the benefit claimer, or for the conservation and promotion of the resource, or for socio-economic development of the areas. So then again, it contributes to the conservation of biodiversity. So that is how this circle becomes complete. So utilization is regulated to ensure utilization happens only in a sustainable manner. And once the utilization happens, it is ensured that there will be equitable sharing of benefits. So this is how the circle becomes complete. So now this I've already explained, that if you are an Indian citizen, so this slide deals with a person who is an Indian citizen. So I am not dealing with non-resident Indians here. So it's purely an Indian citizen like you, or an Indian institution. So you, instead of using your name, once you develop a patent, you may be filing in your universities or your college name. So in that case also, it is an Indian institution, which is not having any foreign shareholding or foreign participation in management. So in that case, research is not regulated. You are free to do research. But in case of commercial utilization, prior approval of State Biodiversity Board is required. Similarly, if you transfer the research results to a Section 32 entity, that you do research and then you transfer it to a foreigner or a foreign college or a foreign university, then you have to take approval from the National Biodiversity Authority. So here I should clarify that if you are making a presentation in some conference or some seminar, this is not applicable. Similarly, if you publish an article or some scientific publication, or if you write a book, that also doesn't require the permission. But if you are transferring it to another person, then it requires the approval. Similarly, intellectual property rights that I already explained, whether it's an Indian or a non-Indian, you have to take the approval. So here in this slide, I am speaking about foreign citizens or body corporates or associations which are foreign in nature, that they are registered or incorporated in outside India. So the company that I told you about, the company which is based in Switzerland, so it's a foreign company. Similarly, a company which is registered in India, but it is having foreign shareholding. So a company which is a company usually which is listed in the stock exchange, so it has some foreign shareholding. So then they are also coming under this category. So they does require approval for research. They does require approval for commercial utilization. They require approval for transfer of biological resource. They also require approval for intellectual property rights. So whatever is the activity, whether it's research, commercial utilization, if it is a foreign individual or a foreign citizen or a foreign company, then they have to take the approval from the National Biodiversity Authority. So now I hope you might have understood the distinction, that if it is purely an Indian, then research is not regulated. For other activities, you have to take approval from the State Biodiversity Board, and only for patenting, you have to come to National Biodiversity Authority. But if it is a foreigner or a foreign company, then for all these purposes, they have to come to the National Biodiversity Authority. So similar to this, now we have been discussing about Biological Diversity Act. So similar to Biological Diversity Act, the Patent Act also has some similar provisions. So the Patent Act also has some provisions which says that whenever a biological resource is used for developing the invention, the source and geographical origin of the biological resource has to be mentioned in the complete specification. So that is why when I explained about patents, I show you one slide wherein that detailed description of invention is there. So you develop an invention in your lab. When you apply for a patent, the patent agent, of course, you have to consult with the patent agent, and the patent agent will help you to draft it. So when you draft it, it will be in the form of a detailed description. So in that detailed description, you will be explaining how the invention can be performed. So in this detailed description, you have to mention the source and geographical origin of the biological resource. So if it is taken from Tamil Nadu or in Thoothukudi district in Tamil Nadu, then the patent application should mention that it is taken from this place in Thoothukudi in Tamil Nadu. So it is mandatory under the Indian Patent Act. So here I am showing one example wherein the person who applied for the patent has used Vitania somnifera. So you know what it is. So they have taken it from Ramakrishna Mishra Ashram, Narendrapur, Kolkata. So in this I have taken, this page I have taken from the patent application filed by them. So in the patent application, they have mentioned that I have used this resource, which is taken from this place in Kolkata, West Bengal. So that is how it has to be mentioned. So once you file a patent application, it becomes a proof that you have used this material, which is taken from this place. So then it becomes a proof. So then you have to, of course, you have to take the approval from the National Biodiversity Authority. Unless you take the approval, the patent office won't grant the patent. So now we come to traditional knowledge. So traditional knowledge, I need not explain to you what is traditional knowledge. You know what is traditional knowledge. It is transferred from generation to generation. It is knowledge derived from your ancestors. So there are mainly under the Indian law, there are three different kinds of protections given to traditional knowledge. So one is in the form of documentation. So second one is under the Patent Act in the form of a defensive protection. Third one is a regulation on access and use under the Biological Diversity Act. So first we can discuss about the documentation of traditional knowledge. So as I told, if you don't document traditional knowledge, very soon it will become extinct. That no one will know about the traditional knowledge. So now our parents know, our grandparents know. So at least now we should do a mass exercise to document traditional knowledge. So unless it is documented, we will not be able to transmit it to our coming generations because it will be lost forever. So we have the TKDL, Traditional Knowledge Digital Library, set up by the CSIR. So you might have heard about this. So there is a digital library to document traditional knowledge, which is already in the form of literature. And there is also a massive exercise happening in the form of electronic people's biodiversity registers. So when I explained one of the slides, I told you about the Biodiversity Management Committee. So Biodiversity Management Committee is also an institution under the Biological Diversity Act. So every local body will have a Biodiversity Management Committee. So one of the most important functions of a Biodiversity Management Committee is to document the biodiversity and traditional knowledge. So they will have to prepare a people's biodiversity register. So being faculties who know about biodiversity, it is your role also to participate in the preparation of people's biodiversity register. Because a common man may not know how to document biodiversity, but experts like you know. Even I don't know how to document biodiversity because I am from the legal field. But you know what is a biological resource, what are its characteristics. And when someone says you about a traditional knowledge, you will be immediately able to understand what it is. So then it is your role to document biodiversity. So it can be documented in the form of PBR, People's Biodiversity Register. And now there is an exercise happening at national level to create electronic People's Biodiversity Register. So it will very soon in the form of an electronic electronic database. So this is what is happening in the context of documentation. And there is provision for defensive protection under the Patent Act. So when you apply for a patent on a traditional knowledge, it will not be granted because the Patent Act has a provision which says that if it is in effect traditional knowledge, then it cannot be patented. So if it is in effect traditional knowledge, then the patent office will reject it during the examination stage. And it is, if by mistake it is granted, then it is a ground for pre-grant and post-grant opposition. So any person comes to know that a patent is granted on traditional knowledge, they can object to the patent and the patent will be rejected or it will be revoked. So there is also regulation of access and use under the Biological Diversity Act. So it is section 6 under the Biological Diversity Act that deals with patenting. So whenever a biological resource or a traditional knowledge or an associated knowledge is used for the purpose of developing an invention and then it is patented, then prior approval from the National Biodiversity Authority has to be taken. So there is regulation on access and use of traditional knowledge. So these are the different mechanisms to protect traditional knowledge in the Indian law. So now I have already told you what are the regulations on research, what are the regulations on commercial utilization, what are the regulations on patenting. But there are some exceptions to this. So I will now go on to the exemptions under the Biological Diversity Act. So first exemption is human genetic material. So when I explained about biodiversity or biological resource, I told that it encompasses everything that is having a form of life, but it doesn't include human genetic material. So when you do research on human genetic material, it does require approval under some other laws. That is a different issue, but it doesn't require approval under the Biological Diversity Act. So Biological Diversity Act usually deals with plants, animals, and other microorganisms, but it doesn't deal with human genetic material. So if your research is purely on human genetic material, then you doesn't have to take approval from the approval under the Act. You have to take other approvals under, you have to take the ethical clearance, other clearances. That is a different issue, but you doesn't have to take any approval from National Biodiversity Authority. So there is also an exemption of normally traded commodities under the Act. So far around 421 items, 421 biological resources have been notified as normally traded commodities. So these are items which you will normally use for food purpose or normal consumption purpose. So these cannot be regulated. Then it will lead to a lot of complications. So the government has notified 421 biological resources as exempted articles under the Biological Diversity Act. So if you are using it for the purpose of a customary purpose, like if you are developing a juice out of orange, or you make apple juice, or any other thing which is commonly done, then you doesn't have to take approval. But if you are planning to do research, or if you are planning to take an intellectual property right, then approval is required. So that is the distinction. So this is not applicable for you, because being researchers, you will be either doing research or you will be taking intellectual property right. So in both the cases, whether it is an NTC item, we usually call it as NTC, which is it is a normally traded commodity. So whether it is an NTC or a non-NTC item, you have to take the approval. Similarly, there is another exemption for under the International Treaty for Plant Genetic Resources and for Food and Agriculture. So this is also not applicable for you, because even those articles listed under this notification can be exempted for the purpose of commercial utilization, for the purpose of research, but these are only for very limited purpose. Similarly, there is another category, because I was speaking about patents, but there is another category of intellectual property right called plant variety protection. So I hope you might have heard about plant variety protection. So there is an act called Plant Variety Protection and Farmers' Rights Act by the central government. So it is the authority under the act is known as PPFRA, Plant Variety Protection and Farmers' Rights Authority, which is based in Delhi. So if you develop a new plant variety, so instead of doing research and developing an invention, you are developing a new plant variety as such. So that plant variety can be protected as a kind of intellectual property right under the PPFRA Act. So if you are taking a protection under PPFRA Act, then approval under the Biological Diversity Act is not required. So if you are developing an invention which you are planning to take patent, approval is required. But if you are developing a new variety which you are planning to register under the PPFRA Act, then approval is not required. Similarly, foreign biological resources. So we know that many of the resources, even in Thoothukudi port, many of the biological resources from foreign countries also comes. So you might be getting orange or apple from Australia, you get it from Europe or different countries. Also from Sri Lanka, also many biological resources comes to India. So then these kinds of foreign biological resources are not regulated under the Biological Diversity Act. So Biological Diversity Act in India deals with only Indian material. So you doesn't have to take approval from NBA or the State Biodiversity Board. But at the same time, you have to be very careful when you deal with foreign biological resource. So if you understand that this material is coming from this country, you have to also check and find out whether there is any law like Biodiversity Act in such country. Then you have to follow that law. So you have to take the approval from that country. That is required. Otherwise, it will lead to some complications when you try to publish the research or when you take a patent. So it may lead to some complications. So it is always better to do a due diligence. And if you are using a foreign material, you find out the law in that country, you consult with the patent agent or experts like Dr. Deepa, and find out what is the law that you have to follow. So in case if the patent office is objecting, usually the National Biodiversity Authority will grant a no objection certificate. That is the usual procedure. So similarly, mechanical devices are also exempted are also exempted from the purpose of the Biological Diversity Act. So the inventions, so I was telling about biological resources and the inventions developed using biological resources. But what if it is a mechanical device? You take the example of a mosquito repellent device. So when you describe the invention, you also describe mosquito. You also uses the word mosquito, or you use the name of the liquid that you are going to use. So it may be a neem extract or some other extract that you're going to put in the mosquito repellent device. But if your claims are on the device alone, if the claims doesn't extend to the liquid part or the research on biological resource, then you need not take approval. It will be exempted. So similarly, if your invention is the common example that we say is a pressure cooker. So in pressure cooker, you will put a lot of biological resource, but your invention is actually a mechanical device. So for working the invention or to test the invention, you may require biological resource. But your main invention is not a biological resource, but based on a mechanical device. So that also doesn't require the approval. So similarly, testing purpose. So if you use a biological resource just for testing purpose. So for example, if you want to test a chemical invention or a chemical compound, you use a mouse or any other organism, then for that also you doesn't have to take the approval. So when I started the presentation itself, I told that every law that regulate your activity or every law that is applicable to your field of work, you should be very familiar about that. And even if you don't have a good understanding, you don't have a detailed understanding. For detailed understanding, you can consult with a patent agent or legal experts. But you should have a preliminary understanding as to when you have to consult a patent agent or when you have to consult with a lawyer. Because unless you don't have that preliminary understanding, you will carry on with your activities without taking the approval. That is the difficulty here. So the threat under the Biological Diversity Act is many of the, if you undertake a activity without taking the approval, these are all offenses under the Act. These are all offenses which are punishable with imprisonment and fine. So if you commit an offense under section 3, 4, and 6 under the Biological Diversity Act, then it is punishable with imprisonment up to 5 years and fine up to 10 lakh rupees. So if you apply for a patent on a biological resource based invention without taking the approval from National Biodiversity Authority, it can be in India or abroad, then that offense is punishable with 5 years imprisonment. So before you apply for a patent, you have to take the proper permission from the National Biodiversity Authority. So similarly, if you do commercial utilization without taking the approval from the State Biodiversity Board, it is punishable with imprisonment up to 3 years and fine up to 5 lakh rupees. So all these offenses under the Biological Diversity Act are cognizable and non-bailable. So that is why I said that you should have a basic understanding about the law that regulates your field of work. So then you know when to consult a lawyer or when you have to consult with a patent agent. So of course, when you file for biodiversity act approval or when you apply for a patent, you usually have to consult with a patent agent. But then you need to know that when you undertake a research or when you collaborate with another scientist, usually you don't consult with a patent agent or a lawyer. But now you know that when you collaborate with a foreign entity, when you are taking a foreign funding, you have to go and consult with the lawyer, or you have to understand the law and to see what kind of regulatory approval you have to take. So if you don't take the regulatory approval and you go on with the activity, then all these are punishable offenses under the Biological Diversity Act. So this is cognizance of offense can be taken by these are the officers under the Act who are entitled to file a complaint if there is a violation of the Act. This is also notification. So now I'll come to processing of applications by the National Biodiversity Authority. So now all the applications to National Biodiversity Authority can be made through online. So this was officially launched in 2017. So when you usually give this information, whatever information is required to your patent agent, and patent agent may be filing this. So this can now be filed online, and it is very user-friendly process. So for different activities, the fees are also prescribed in the rules. So that is why I said rules. So the act is enacted by the parliament or by the state legislature. The rules are made by the government. So the government will prescribe the rules, and the rules will provide for the fees. So if you are planning, if you are an Indian citizen and you want to undertake research, no approval is required. But if you are a foreigner and you want to undertake research, then you have to take the approval, and you have to pay a fee of rupees 10,000. So the fee is already given here. You can see that if I think in your case, mostly it will be only Form 3 will be applicable when you apply for a patent. The fee is only rupees 500. So that is the fee for the getting the approval from the biological diversity authority. So once you apply, then it goes through a very detailed process. A preliminary examination will be done by the scientific and the legal review team. And then if required, they will consult with an expert committee. And then it will go through a detailed process. And finally, the agreement will be sent to you maybe through your patent agent or maybe directly. Then you have to sign the agreement, and you have to prepare it in a stamp paper. And then once it is signed, it constitutes the approval of National Biodiversity Authority. And then you have to upload this information, and then the authority will upload this information to the ABS clearinghouse portal. So once, if any of you have applied for NB approval, or any of you might have got the approval, you will be knowing that you will also be getting an internationally recognized certificate of compliance. So this internationally recognized certificate of compliance, you can even include in your publication. You can include in your profile that you have secured the internationally recognized certificate of compliance. So it will add value because it shows that you have followed all ethical guidelines related to biodiversity research. So it shows that you are a law-abiding citizen, or you are a law-abiding scientist. So once the IRCC's information is uploaded, it will be generated, a copy will be sent to you. So this is the percentage of benefits that will be shared. This is in accordance with the guidelines which was notified in 2014. So as per the guideline, these are the different ranges at which the benefit will be fixed. So in case of patent, it varies from 0.2 to 5%. But this benefit has to be shared only when you make a profit, or only when you do the commercial application, whether it's of a patent or whether it's of a product. So before I conclude, before I go to the next part of the presentation, I will also explain some of the common mistakes that people make while applying for approvals. So one is that due to ignorance. So as I told, if you are an Indian scientist or an Indian faculty, then you need not take any approval for doing research. But if you engage with a foreign collaborator and you transfer anything to the foreign collaborator, then you have to take approval. Similarly, when you apply for a patent also, you have to take approval. So when you do these kinds of activities, you have to see in whose name the application has to be filed. So many times I have come across situations where individuals file in their own names, but patent will be filed in the name of your college or university. So if a faculty in your college files for a patent, it will be in the college name. So then this application also has to be filed in the name of the college or in the university's name. And it should be signed not by the individual researcher, but by an authorized person of the institution, like the principal or the director or the vice chancellor, or the registrar, as the case may be, or the vice chancellor or the principal can authorize a person or a faculty to sign. Then the authorization also has to be attached. Similarly, if the patent is transferred to another agency, for example, you are doing this under a DBT project or CSIR project or any other ICR project, then you might have transferred this to ICR or DBT. Then their name also has to be included. Then you have to give all the information, whatever information you have. Just like when you file for a patent, you have to include all the information in the application. So, and then there will be situations where there is mismatch in title. So whatever title you are giving to the patent application, that same title has to be mentioned in the Form 3 application also. And then scientific name also, scientific name and common name also has to be given. And then there is another common mistake that I already told, that some scientists may be taking only turmeric powder, which they have bought from the market. Or you may use an oil extract, or similar kind of thing that you purchase from the supermarket. But still it is required. It is required under the law to take approval. So whether it's an extract, whether it's in a powder form, still approval is required under the Biological Diversity Act. So these are some common mistakes. I need not go in detail because you have to, of course, when you come to such a situation, you have to consult with an agent or lawyer to do this. So there is also Form B and Form C. So Form C is actually when you Form B is actually when you want to send a material abroad for an emergency purpose. For example, you want to do a taxonomic identification of a particular biological resource. Then you have to send it to a foreign university and they have to do the taxonomic identification. Then you can use Form B. Or similarly, if you want to do a analysis, then for that analysis purpose alone, you are sending the material, then Form B can be filed. So then the approval will be usually given within 45 days. But then the foreign counterpart should not be using this material. That you have to make sure. So if it is just for testing purpose, once the material is sent, the analysis will be done. The results of the analysis will be sent back to you. They won't be using the analysis. Then this form can be used. Similarly, there is another form called Form C. This is actually for depositing of microbial strain in a foreign repository. So you want to deposit a microbial strain in a foreign repository for claiming the novelty of the species. Then Form C can be used. So as I told, the collaborative research, general collaborative research that you undertake with a foreign university or a foreign researcher requires the approval under the Biological Diversity Act. But if it is a collaborative research, which is approved by Government of India or a state government, or they issue a notification. So there will be multilateral or bilateral agreements with different countries. The Government of India might have entered into some agreement with a foreign agency to doing some research. So if it is under that particular agreement, and then your research is notified by the government as a collaborative research, then it may be exempted for the purpose of Biological Diversity Act. So, but still, if you are applying for a patent, approval is required. But just for the purpose of collaborative research, then approval may not be required. But if you have any doubt, it is always better to consult with the agencies or your lawyer or your patent agent to see whether approval is required or not. So the Act also provides for some conservation measures also in the form of biodiversity heritage sites. So these are sites which has some biodiversity importance, which can be notified by the state government as a biodiversity heritage site. So once it is notified, then there are certain rules and regulations that are applicable to that site, so that it has to be preserved. Similarly, the species that are in the verge of extinction or that are threatened can also be notified by the government. So it is already notified in 18 states and 2 union territories. Some of the species has been notified. So once it is notified, its access and utilization will be regulated. So now I have been speaking about the interface between biodiversity and IPR. So I have already told you some cases where patents are being taken in foreign countries. So how to deal with such situations? So for that, National Biodiversity Authority is vested with some powers to monitor patenting activities on Indian biological resources. So what they do is they will have a detection strategy. So they will periodically search to find out patent applications using Indian biological resource. So if you take the example of an Indian patent application, so if you file an Indian patent application, you have to when you file the patent application itself, you have to give an undertaking that if you are using an Indian biological resource for research, you will take the approval from National Biodiversity Authority. So when you file the patent application online, it will come as a pop-up message, which you have to agree before you go to the next stage. So in that pop-up message, it will be shown that if you are used any Indian biological resource for doing research, you have to take approval from National Biodiversity Authority, and a copy of the approval has to be submitted to the patent office. So only after you submit the approval only, the patent office will grant the patent. But if it is a foreign patent office, they will simply grant the patent without looking into these aspects. So for that, NBA will have a detection strategy wherein they will identify patents being filed on Indian biological resource. So once they identify, they will initiate some monitoring measure and they will inform the patent office that it is a violation of the Indian legislation. And they will also ask the patent process to be stopped. So before I close the presentation, I will share some stories that this is a case where turmeric is used by a university based in Belgium. So what they've done is they have sourced curcuma longa from a local supply, but this material has originated from India. So the material has gone from exported from India and reached Belgium market. So the university researcher has bought it from the market and they've used it for research and they have developed an invention. So this actually requires the approval, but they did it without taking the approval. So immediately National Biodiversity Authority filed an objection and now they have complied with the act. So this is another example wherein Botany somnifera is used by a company based in US. So the company belongs to energy service sector. So what they have done is they have sourced the material from Pune, and then they have done some research and developed an invention. So same is the case here also. During the monitoring only, the Indian authorities have found out that such a patent application is filed. So this is another example of a company based in nutraceutical sector. So they have used papain, which is derivative of papaya, and they have sourced it from Bangalore. So you can see, if you look at the patent details, you can see that patent application is filed in a number of countries. So usually, I don't know how many of you have filed for a patent. So if you already filed for a patent, you will be knowing, like sometimes you apply for patent only in India. But if it is having a huge commercial potential or a huge economic potential, then you will file in different countries. You will apply in Australia, you will apply in US, you will apply in Europe. So only if it is having a commercial application, you will file in this many number of countries. So this patent, if you see, it is filed in many countries: Australia, Brazil, Canada, China, Indonesia, New Zealand. So that means it is having a huge commercial application. So this also was found out during the detection process. So now, before I close the presentation, I shall also tell you how you can help in the implementation of this law. So first thing is that you should have an understanding that whenever you do research, or whenever you do commercial utilization, or whenever you apply for a patent, you have to follow the rules and regulations in this country. So then you need to have that basic understanding about the law that regulate your field of research. So that is the most preliminary thing. And then you have to spread this message among your colleagues, that when you interact with your colleagues, you have to tell that you have heard about this legislation. So when you do research or when you apply for a patent, you have to take this approval under this act. So you can spread this message to your friends. So, and whenever your friend or a colleague is applying for a patent, you can advise them that this may also be required to take the approval. Otherwise, it may lead to a violation, which is a punishable offense. And you can also inform them about the 5 years imprisonment thing in the act. And whenever you come across violations, so being academicians, you will be coming across patent applications or articles or scientific publications from different scientists across the world. So if you come across the use of an Indian material, and if you feel that it's a violation, then you immediately notify the authorities under the act, either the State Biodiversity Board or the Forest Department or the National Biodiversity Authority. Inform them, you report violations. Then, as I told, your village panchayat or your local body may also may be having a biodiversity management committee. So you can help the biodiversity management committee in their function. So they don't have the they may not be having the technical expertise to prepare the people's biodiversity register. So you can offer them the support, and also you can involve your students in the process, in the process of documentation of biodiversity. Then if you protect nature, nature will protect us. So do whatever is possible to protect nature. So with this, I'm concluding the presentation. If you have any questions, you can ask now, or you can either, if you want, you can also put in the chat box. So
dear participants, we will go ahead and take some time for question and answer session. Now you can share your questions in the chat box or by unmuting your mic. Dear participants, you can ask your queries to sir. Flora ma'am?
Hello.
yes, I can hear.
Flora ma'am, hello?
Hello, sir. It's a very nice presentation. You have elaborated everything regarding the Biodiversity Acts. Everything is highly informative, sir. Nice presentation.
Thank you, ma'am. Thank you.
I think there is no questions in the chat box. Thank you, sir, for your lively presentation and for providing the important aspects of patenting that everyone should be aware of. Now I request Dr. Flora, Assistant Professor of Botany, to deliver vote of thanks. before that, we want to get feedback from the participants. Dear participants, you can share your feedback with us.
Very good evening to you all.
Good evening, sir.
Yes. Ma'am, I want to give my feedback. Is it okay?
Yes, sir.
Yeah, thank you, ma'am. So first of all, I'd like to thank the principal, deputy principal, head of the department, Malar ma'am, and Dr. Flora and organizers for this wonderful FTP program. So very good to them. And today's resource person was really excellent, Dr. Narendra. It's a very good presentation, sir. Thank you very much. It enlightened all of us. It was indeed, we had many doubts, but everything you have clarified it. So thank you very much, sir. About the program, I just want to highlight some merits of the faculty development program, which was organized by the college. It is a wonderful opportunity for all our participants. The first thing is the planning. The planning of the program, FTP program, was really fantastic. Meticulous planning, and the structure of the program, the topics of the program, everything was meticulous. So very kudos to the entire organizing committee. And the second part is the resource person, those who engage the sessions were really expert in their fields, highly qualified, and they were really expert in that particular subject area. And it is wonderful opportunity, and it's a gift for us for this in this particular FTP. And about the timing and the punctuality, I know about the college and the St. Mary's College. It was wonderful that the timing which they maintained was excellent. So if it is 4, the program was started. So it is a wonderful thing which to be noted. And all other programs where they will tell 5 o'clock and start at 5:30, it was not like that. So meticulous. It was very wonderful, the timing. And the resource person, as I already mentioned, it was wonderful to hear from the experts' point of view. It was great. And we all miss actually St. Mary's College to be there physically, because since I visited the St. Mary's College, it is so clean. The management, it is a wonderful opportunity, all of participants to visit at least once a lifetime in a physical mode of faculty development program. So on behalf of all our participants and other resource persons as well, I like to thank for this opportunity, and it's a wonderful program. Thank you very much. And a special thanks to Dr. Flora, who has organized the entire event, for fixing the resource person. So thank you, Flora ma'am, personally. Thank you very much.
Selvanandi? Hello? Hello, ma'am. Can you hear me?
Yeah.
Okay.
If any no more questions, shall we propose formal vote of thanks?
Okay, ma'am. Yes, ma'am.
Okay.
There is no questions in the chat box.
Good afternoon, everyone connected here. It's my pleasant privilege to propose vote of thanks. I'm delighted to thank our resource person for his elaborate lecture, and he has enlightened all the participants with broad aspects of biodiversity acts and that. Sir, really, it is highly informative. On behalf of the Department of Botany and Management, I extend a hearty thanks to you, sir. And this is my also duty to welcome our Sister Principal, Dr. Sister Lucia Rose, our Secretary, Sister Flora Mary, for making us to arrange all this program of Mega Dimension. I thank all my department colleagues and the organizing committee for making this function a grand success. Thank you, Anandal. Thank you so much. Thank you, sir.
Thank you, sir.
Thank you very much, madam. Thank you very much for this opportunity. I also enjoyed it very well. Thank you very much.
Thank you, sir.
Salvanandi?
Yes, ma'am, we can hear you.
Okay. Every beginning has an end, and every soul that endeavors for perfection will strive hard to make all things beautiful. So for a beautiful beginning, here is a finale that ends with great satisfaction. A note of gratitude to all who contributed to the success of the deliberation in this FTP program and IPR, organized by Department of Botany, Marian Star Center, St. Mary's College, Thoothukudi, under DBT Star College scheme. My sincere thanks to Almighty God for his guiding presence for the whole event. By his blessings and grace, we were able to make the event a meaningful and fruitful attainment. I would like to express our sincere gratitude to our Secretary, Reverend Sister Flora Mary, and our Principal, Reverend Dr. Sister Lucia Rose, for being the catalyst that inspires us to do our best and stand as a pillar of motivation. I would like to acknowledge with gratitude Reverend Dr. Sister Kulandai Daras, Deputy Principal, for her prominent leadership and administering support and encouragement in our endeavors. I take this opportunity to express our sincere thanks to our head of department, Dr. M. Glory, for her constant encouragement and always exuding positive energy in conducting each and every program, and this program too. I owe my special gratitude to Reverend Dr. Sister Arokya Genesius Alphonse, the overall coordinator and member secretary of the Star College scheme. Her active involvement and planning has made this program largely a beneficial one. I would like to express my sincere thanks to our resource persons, Dr. M. Saktivel from Guru Gobind Singh Indraprastha University, New Delhi, Dr. Tiba, registered patent agent, Mr. A.K. Rajaraman, Advocate, High Court of Madras, Dr. P.R.L. Rajavengadeshan, Associate Professor and HOD, BIT School of Law, and Dr. Narendran, Triti Rajiv Gandhi School of Intellectual Property Law, Indian Institute of Technology, Kharagpur, for accepting our invitation and delivered resourceful lectures in different topics on IPR. Participants had enriching sessions and had gained expert knowledge on IPR. The outcome of this FTP program has provided is worth all the hard toil undertaken by the organizers and experts. We thank wholeheartedly the entire team of hardworking, tireless brains and voluntary hearts for making this program a resounding success. My heartfelt thanks to the members of Department of Botany for your dedication and support to conduct this program. My sincere thanks to all those who work behind the scene to execute this event, most especially Ms. Pauline Jennifer for the technical arrangement. Last but not least, with all sincerity, I thank all the faculty participants from all over India for their active and enthusiastic participation and giving your valuable feedback every day. Thank you all once again and wish you to stay safe and keep safe. Thank you.
Thank you, ma'am. Dear participants, before leaving from the meeting, kindly fill out the attendance cum feedback form. The link has been posted in the chat box.
Ma'am, excuse me.
Yes, ma'am.
Good evening, ma'am. Actually, we have attended a last event also, but still we didn't get the certificate.
Yes, ma'am. Yes, ma'am. It will be sent to you within 2 days, ma'am.
For this event, when we will get the certificate, ma'am?
For this event,
we will provide the certificate after 2 weeks, ma'am.
Okay, ma'am.
Okay.
Okay. Thank you, ma'am.
Thank you, everyone. We appreciate you for taking time off your busy schedule to join us today. Thank you all.